Hi guys, asset protection attorney here, Brian T. Bradley, and I'm sure you guys have, heard and seen me on a lot of other investment podcasts and features and shows. But I just want to go over a little roadmap for you California residents. And there's a lot of questions on LLCs versus DSTs and PRPs. And I just want to update my prior video just with a little bit more information for you guys. So let's just go over this key concepts from the roadmap here real quick of investing in real estate for you California residents and what some of these options are. So this is a little bit easier for you to clear up. The first big concept that comes to protecting real estate is that equity and cash flow are really what matters at the end of the day. It's not fair market value. Real estate almost has debt with it. Unless you own it in cash, you're going to carry some debt. And what this means is that, for example, a building worth 3.5 million, and you have 3.2 million of debt actually has a less net value to the owner of a building that has $650,000 and that's fully paid off. It just goes to the saying that gross value is vanity, net is sanity, and cash is king. Why you care about this for asset protection purposes is because if you have a judgment creditor and they're looking to collect on the judgment, they don't care about the gross value of your property. They only care about what the net equity is that they can get from it today at that moment right now and what the cash flow is. And so what this means is that debt, if it's properly used, can protect the value of your property by reducing the equity and making your property less attractive to the creditor if you were to be potentially sued. And because there's nothing there for them to collect on and they're in a lower order of priority. This then goes into the next concept I quickly want to talk about is inside versus outside liability. Inside liability is liability that comes from inside your business, from your business activities, contracting and all of that. Like having an investment property inside an LLC and then somebody gets hurt or the house burns down or there's a party and somebody gets drunk and drives and kills somebody while they were drinking and driving. The creditor's claim is that the liability to that is inside the business. Now, if you have one property and one LLC, that's fine. But what if you have four properties, and you only have one LLC? One property explodes and now it affects all of the other properties in that LLC. That's where you want to start dividing up properties out of into multiple LLCs and other entities. Outside liability or personal liability is liability that comes from outside your business, like from your personal life. You driving your car out on a personal errand, hitting somebody with your own car. The solution here is that you really want to address both types of liabilities when you think about creating asset protection structures. And then we get to the big topics of, LLCs versus all the other options. Everyone knows what an LLC is. You all heard about it. LLCs are good, but they're limited. Just look at the first letter, L. Limited. Like they don't hide that fact. And so I don't want to break down all the good sunshine and rainbow part of LLCs. They're a good starting point. I use them. I advise everybody who's owning something to use LLCs, but we need to understand the limits of LLCs and why, as your net worth starts growing, you need additional higher levels of asset protection. It goes to the principle of legal versus practical authority. And this is really big for real estate investors. The reality is that a judge can and does do whatever a judge wants. What this means is that if you're creating a Nevada LLC and the exclusive remedy against that Nevada LLC is a charging order, a judge, even in California, by statute, may not issue a remedy other than that charging order against the partnership. But that's just all in theory. This doesn't play out in court when you're actually challenged. Most people know it's just common sense. Theory and practicality seldom ever mix. Practical authority is the power that the judge actually has to make decisions. And a judge has very broad powers of reaching your assets. They can seize them, they can place liens on them, they can foreclose on them, they can order a sheriff sale, they can clear title to clean title, they can do wage garnishments. And the problem is that judges, even without legal authority to do all of this, they do these things by exercising their practical authority. And this can be done even in direct contradiction to established statutes and case law. The result is that the court's practical authority, but not the legal authority, just took your asset. So just understand these principles and why the best form of protection are those that hinder a judge's practical authority over your assets. That's why we start getting into exemption planning and offshore Cook Islands trusts when you hit that higher net worth $1 million or more. So just understand there's actual limits to LLCs that you have. And then the next thing is people hear about series LLCs, but you're a California resident, so you can't really use the series LLCs because California doesn't recognize them. And so as you add all these LLCs, you're going to start paying the $800 franchise tax, which can get really burdensome and expensive. So people started using Delaware statutory trust as asset holding companies. This is great if you want to create categorization, separation out of individual assets, like a series LLC. You own one property, put it in series A, own a second property, put it in series B, et cetera, et cetera, et cetera. And as you're creating these series, you're not going to be spending $800 per LLC to hold each asset in. The issue with Delaware statutory trust is that just like LLCs, they're limited. You can't run from the Constitution. Judges can pierce them. We've seen a lot of cases now coming down in California of them being disregarded and the entities pierced. Essentially, it's just saying, I want to protect myself minimally. I just don't want to pay $800 per LLC as I create it. But just understand that there is a limit on the protection that you have with Delaware statutory trust. And this only difference is that it's a tax advantage as long as you maintain compliance with the benefit of it, which is you can't operate out of Delaware statutory trust. You still need a side operating company, LLC. And the DSTs are only good for long-term holds. They're not good for fix and flips or short-term holds because you can't do any business operations out of them. And then that comes down to the next big, golden goose that California has is private retirement plans or exemption plannings. This is great because an exemption is a legal right. An exemption is an exemption. Just for example, think of O.J. Simpson and how he was able to keep his Florida mansion and his 401ks when he was sued for a wrongful death case. It's the same principle. California has an exemption found under 704.115 that allows for private retirement plans. But these are only for assets that your primary purpose is to protect them for your future retirement. Section 704.115 was created way back in the 70s. So it's been around for a while, over 40 years. And so it's really strong. It's an exemption planning. And you can protect a lot. You can protect your cash, real estate, portfolios, life insurance, private equity, corporate stocks, your LLC membership interest, as long as your primary goal is to have them set aside for your retirement. And then the other benefit is that these plans aren't limited like ERISA government regulated plans like your 401k plans, since this is a state right, not a federal right. And so this means there's no 59.5 age limit for distributions. The only big downfall to private retirement plans or PRPs, PRT exemption planning for you California residents is that one, they're expensive. You're going to be looking at, $30,000 to set it up. And two, only about 65% of your assets will qualify for the exemption protection. And these make the most sense when the client has about $10 million of net worth or more and you have a high salary, because then we have more income and assets to create a larger matrix with when it comes to protection and funding these PRP plans. Because when they're challenged in court, the courts want to look at the documentation and the funding evidence that's preserved and how you came up with the number to fund these plans and what was labeled as exempt or not. But the matrix is always going to be limited, and we generally find it to be around 65% of the assets. So then you still have to protect the rest of your assets with excess planning. So there's a limit to what the PRP benefit is also. And then I always find, obviously, I like offshore asset protection trust and the bridge trust, which you can go and watch some of my other videos about, which is combining domestic asset protection trust with the power and strength of the Cook Islands Foreign Asset Protection Trust. And there we can protect almost everything. We don't have to worry about the 65% funding limitations or anything like that. So I hope this helps you California residents and kind of clear up the distinction of LLCs, which are great starting points, but you got to be able to scale up as you protect your assets, DSTs and PRPs, and how to scale into the full strength of the bridge trust and foreign asset protection trust. And if you ever want to get more information, just jump on to my website, www.btblegal.com. I have tons of educational information and videos from all my other podcasts, interviews and features I've been on, a lot of brochures and pamphlets. So it's a great resource for you just to educate yourself. And I hope this video was helpful, and I appreciate you taking the time to listen to this, and good luck investing.